episodes ago, I was talking about making a fan game, and I suggested go ahead and do it because it's a good way to get attention. Many in the comments said that is irresponsible.
Oh.
People you're lucky if you get a cease and desist. Most people get sued, and you don't know about it because they all signed NDAs. So I said, show me the receipts. Let's talk about this. Let's get it straight. In the meantime, we have a sponsor, Hoeg Law, a lawyer.
He's a lawyer.
We have a law firm. And so I emailed Rick Hoeg, and he gave us a lot of information. I had a conversation with him.
3 pages.
A lot of dense information, but it's all pretty interesting to me about how making a fan game can work in the United States and with law. And so, Jones, I would like for you to read this.
I've never met Rick in person. I want to meet Rick so I know what he sounds like.
Are we allowed to read
like
this?
Rick.
We are allowed to. I asked. And
Okay.
We are officially allowed to read this. This is from Rick Hoeg.
There's a disclaimer. For the record, what Rick says here are his general thoughts and should not be taken or acted upon as legal advice, as every situation is different. If you're thinking of pursuing any activity that may run afoul of another's rights, you'll want to consult with your own counsel rather than the Easy A podcast.
Good advice.
As a foundational matter, intellectual property, IP, created by a party, Nintendo, EA, Paramount, etc., is owned by that party. Full stop. Ownership, in this case, affords the creating party with certain exclusive rights which the law protects, including the right to copy, distribute, and, importantly for our discussion, make derivative works from the original IP. A fan-made game is a derivative work of another's IP. Absent a valid defense, its creation is a violation of the IP holder's rights, though the IP holder may have difficulty proving damages. Fair use is the most common defense put forth by fan game and mod creators, and the same applies to fan films, etc. Fair use is a legal defense that basically asserts, pared down a great deal, that use of the IP holder's IP should be allowed because the new product, 1, transforms the original IP, 2, does not take all or substantially all of the assets of the original IP, and 3, does not affect the market of the original IP. If a fair use argument were accepted by the court, then the fan game maker or modder would be permitted to distribute, but generally not sell, their creation. There is a lot we could talk about on this point, but the fight here would usually center around whether or not the new IP affects the market of the original, with broad discretion given to IP holders to claim that the new IP causes it problems in some way, like the Metroid 2 revamp killing the market for Nintendo's own remake before anyone knew the latter existed. The issue here is that fair use is a defense, like insanity for a murder charge. It can only be asserted after legal proceedings have begun. That means that even if a fair use game maker were entirely in the right, and their new product should be permitted under the doctrine, they would have to allow the IP holder to take them to court, adjudicate their claim, and then assert the defense. All in the shadow of losing the case and being on the hook for whatever the original IP holder can claim for damages. Given that Nintendo or Microsoft or whoever generally has more lawyers than the population of some states, almost no one is going to spend the money to assert the defense legally, especially when victory effectively allows the winner to give things away, but not to sell them. If you're familiar with the phrase, you may beat the rap, but you can't beat the ride, it's a similar principle. It doesn't matter how right someone is if they can't afford to play the game. Sad but true.
By the way, I've never heard that phrase before.
There you go.
Also adjudicate.
Adjudicate, sorry. So, as a legal matter, there's really no way for an individual or small group to win a direct fair use argument with one of the big boys. As a practical matter, however, it may be another story. As I pointed out above, in most borderline cases, i.e. not cases where a modder has Mario ripping off President Trump's head or putting Princess Peach in a compromising position, the original IP holder would have a difficult time proving damages. So the method you discuss in the podcast, develop in secret, release, and pull down on any cease and desist, would likely be effective for getting attention to the creators with minimal risk of exposure. Combined with the fact that an IP holder destroying what would likely be a group of its biggest fans would be a PR disaster in most circumstances. I think there are strategic business reasons to think that the fair use game maker would be okay. Going forward with such a project simply has to be on the understanding that the law is not generally on their side, and that there is a non-zero chance that the IP holder has the power, and likely the right, to make their life a living hell if the IP holder deems it desirable. So, 1, don't advertise that you're making your game, because you can't afford to beat the ride. 2, don't simply steal the IP holder's assets, because you need the cover of a fair use defense if it came to it.
Make your own
3,
assets.
Be the IP holder's biggest fans and advocates, because you want there to be a political cost for your destruction. 4, don't make that Princess Peach Does Portland game you've always dreamed of, because there will be damages, and one's easily proven. And finally, 4, 5, understand that if push came to shove, you would have a hard time paying for counsel enough to defeat a claim from the IP holder, even if you tick every fair use box. So you need to abide by that cease and desist if and when it comes.
Cool.
Thanks, Rick.
Wow.
Yeah, I really like that. So here's the situation in the United States of America. You can feasibly, legally make a fan game. Like people are like, Kyle, you're condoning illegal activity. No, you can make a legal fan game. You absolutely can. Here's the thing. You can still get sued for that, however legal it is, and you obviously can't afford it. I cannot afford a legal case against Activision.
Yeah.
However, it also states it's incredibly unlikely for Activision to ever come after me unless what I'm doing is extremely damaging because, one, they don't want to look bad, but also, two, it's not worth it to them. So really, yeah, be aware of the risks if you're making a fan game. They are many, and that's kind of it. That just be aware of those risks is really the message at the end of the day. There are risks. You can get sued your pants off even if you make a completely legal fan game that just takes off too much. So it's crazy. It is a really crazy give and take.
It makes me wonder about like strategic reasons for doing a fan game or fan film or something. Like if you're doing it to try to convince the company, hey, there's demand for this, please make it yourselves. Like kind of what happened with Metroid 2, or like that Power Rangers short film, and then they made a gritty Power Rangers reboot. You know, it's like, oh yeah, people want this that kind of works.
So the
or
context
just showing that you're skilled. And
the context we introduced it with, Ian, was that the person who made another Metroid Prime 2 remake was hired onto Ori and the Will-O-the-Wisps.
Okay.
And so it's also kind of like with the Power Rangers thing, an easy way to get attention.
Yeah.
Your gritty nothing movie gets fewer views than
far
your
less
gritty
attention.
Power Rangers
Right,
movie.
right.
And so, yeah, basically it is a good way to get eyeballs. You can say, oh, the person who made another Metroid Prime 2 remake, as opposed to, oh, that person who made that one Metroidvania type game.
Right.
So it is easier to get attention that way. However, there are risks, and yeah, it could be scary. You could potentially get sued.
Yeah, it's a funny thing because it's like, on the off chance that you would get a sweet job or get a job directing the actual official remake or whatever, or the off chance that your IP that you own hits and then you get a lot of money for selling your own IP, I don't know what would be. I feel like the latter has more potential, but who knows?
It's much more fun to make your own IP. It's so much more fun to make your own game, to make your own world and make your own characters
If it
and things
hits.
like that. If it hits.
True. Yeah,
If
but
it dies on the vine,
but it also
then-
can be a lot of work, especially for someone who's never made a project before, who's going to be making a lot of mistakes going into something. So it's like if you're making something technical,
Yeah.
it's like you have to not only go through all the hoops of thinking like, I think my idea is cool, but I don't know, and now I'm doing tech and writing
Right.
code that's breaking, so I think my idea is crap. I think my code is crap. Whereas like if you're like, God, I love Metroid, then like maybe that'll be enough to pull you through all of these hurdles
It's
holding
actually-
you back from following your dreams.
It's kind of interesting. The Metroid 2, I think, is kind of heinous in that it isn't very transformative. I don't think that is. I would not consider it under fair use because how similar the sprites are and how much music was reused. So, Jones, on that aspect, I think you'd have to say, I'm making a statement on this game.
Yeah.
I'm making a statement on Halo. I'm making a statement on Mario or
Yeah.
something like that to make your game interesting, to get the eyeballs. Just go, oh, yeah, that's cool. That's a cool
Yeah.
take. I like that.
Well, and if you do, if what you're after is eyeballs, then yeah, because like a middle of the road, you know, whatever, like Portal or whatever, short film or whatever, you know, is gonna get a lot more attention, like you were saying,
Yeah.
because of the IP that it's attached to or you know taking from. So yeah, you could be not saying that any of these are bad, but like you could have a lower quality thing get more attention.
Yes,
Yeah.
if it's using someone else's
Right.
IP. Yeah, but it's risky. And so, yeah, everybody's aware of that. We all know now. Thank you, Rick Hoeg. Thank you for that. That was cool. It was
Legal
really
counsel.
interesting.
Like,
Well
not
detailed.
unofficial.
No,
legal
no,
counsel. Don't
actually
use
not
it
legal
as
counsel.
counsel. Information from a
Just some
legal
information.
person.
Yeah, that was fun.
Yeah.
Good information.